YNW Melly's bond hearing erupted into chaos as the judge unleashed a fiery outburst against him and his legal team, turning the courtroom into a tense battleground.
I didn't ask for I don't understand your continued behavior, speaking out of turn, yelling at someone with that censure.
Did this courtroom clash just crush YNW Melly's shot at freedom? After 6 long years behind bars, with tensions at an all-time high and the threat of the death penalty looming, the explosive moment during his latest bond hearing could be a game-changer for the Florida rapper. The truth behind this legal drama is wild. So let's break it down. First, a quick recap. Born Jamel Maurice Demons, YNW Melly has been locked up since February 2019. He's facing 2 counts of first-degree murder, accused of killing his close friends Anthony William, aka YNW Sackchase, and Christopher Thomas Jr., aka YNW Juvie, in Miramar, Florida, back in October 2018. Prosecutors say Melly and fellow rapper Cortland Henry, YNW Bortland, shot the 2 inside a car and then staged the scene to look like a drive. First trial ended in a deadlock in July 2023, when the jury couldn't reach a unanimous decision, leading to a mistrial. Now, with a retrial locked in for September 10, 2025, Melly's legal team is fighting to get him out on bond, while he awaits round 2 in court. This May 6th bond hearing marked their second attempt to secure his pre-trial release. According to court filings, his lawyers, Mr. Benjamin and Ms. Liberty, have been building this motion since November 2024. They argued that a lot has changed since Melly was first arrested and that he deserves a shot at release. But when the hearing got underway, Judge David Porter came in ready to go. As he flipped through the past motions and case history, the courtroom atmosphere turned electric. Both sides were locked in, ready to make their case. Melly's defense came out swinging with a bold strategy to push for his release. But what happened next turned the whole hearing into a courtroom firestorm.
Page 4, this is State of Florida versus Jamel Demons, 19-1872 CFA, 23-10594 CFA. Ms. Collins, Mr. Griffiths, Mr. Silvershine present for the state. I've got Mr. Lee, Mr. Eggleston, Mr. Benjamin.
Things got spicy when the defense attempted to introduce testimony from expert witness Dr. Cuthbert, who had apparently just been added to their team. The prosecution wasn't having it. They immediately objected, arguing they hadn't received proper notice or any of the paperwork related to her testimony. The surprise move threw the courtroom into a frenzy, escalating the already high-stakes hearing.
Because she was noticed in state less than 36 hours ago. She's going to be testifying as an expert. We don't know what documents we should rely upon. We don't know what materials she's able to review. We could have filed bail reports in order to know the substance of her testimony.
The judge ultimately sided with the prosecution and shut down Dr. Cuthbert's testimony, handing the defense a major L. With their expert off the table, Melly's legal team was forced to pivot and rely solely on legal arguments, completely shifting their strategy for the hearing. One of the biggest points of contention was over-suppressed evidence. Back on December 21st, 2023, Judge John Murphy had issued an order tossing out certain evidence that had been obtained in violation of Melly's constitutional right. Now the defense argued that this evidence had no place in the bail. The prosecution fought to keep it on the table, setting off another intense courtroom clash.
I wouldn't call it an exclusionary rule, but I'm saying it should not be considered by the court because the court, the law of this case is it was suppressed and it cannot be used by the state in any way.
After a heated back and forth, Judge Porter sided with the defense, ruling that he would not consider any evidence that Judge Murphy had previously suppressed. This was a major win for Melly's team, as it meant some potentially damaging evidence wouldn't factor into the bail decision. The hearing then dove deep into the specifics of which evidence had been suppressed, breaking down various warrants tied to Melly's social media accounts, cell phone records, and other digital data. Both prosecution and defense spent a significant amount of time hashing out exactly which pieces of evidence were still admissible and which were off limits due to the suppression order. One of the biggest reveals was that the cell site location information from October 26, 2018, the day of the alleged murders, was still valid evidence. This meant that potentially incriminating data could still influence the judge's decision on whether to grant bail.
Cell site location information
Remains
on
in.
October 26, 2018. None of that.
Correct.
After clearing that up, both sides laid out their arguments around the proof evident and presumption great standards that apply in bail hearings for capital cases like Melly's. Under Florida law, if the evidence of guilt is strong, enough meeting the proof evident and presumption great thresholds, the defendant can be held without bail. However, even if those standards are met, the judge still has the authority to grant bail under special circumstances. The prosecution
That's the case law provided to the court. There's actually a presumption of correctness as to Judge Murphy's order, that there was proof evident presumption great. So really what the court is considering now is just effectively has that suppressed evidence that the court is now considering change the state's position where proof evidence is no longer present. We believe that proof evidence still remains strongly present because, as the court was noting, all the information from the day of the homicide remains.
The defense fired back with several crucial points. First, they highlighted that the jury in the first trial couldn't reach a unanimous verdict, suggesting the evidence wasn't as airtight as the prosecution claimed. They also called out Detective Mark Moretti, accusing him of attempting to suborn perjury. On top of that, they pointed to new search warrants obtained after Judge Murphy's suppression order, implying the prosecution was trying to bend the rules and play dirty.
For the purposes of the proof evidence, I have some factors. I know because everybody has a couple. If I could judge, I believe that the rulings by Judge Murphy, that starting with the testimony of Michelle Boutros, which the Judge Murphy ordered the state that when she testifies, they cannot cross-examine her in any further proceedings. The state appealed it on a motion, on an appeal, a writ of some sort, I forgot which one, and that was, and I attached it to my supplement. The fourth denied their seeking relief on that issue.
The defense then presented their proposed conditions for Melly's release, suggesting a minimal monetary bond, along with several strict requirements. Melly would stay at a new residence with no weapons allowed, wear a GPS ankle monitor, and have 24-hour security surveillance. They argued these measures would ensure public safety guarantee Melly's appearance in court and uphold the integrity of the judicial process.
So, the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community, to his mom, his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That proof evident great, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those three things? Make sure he's present here.
The prosecution wasn't convinced. They stressed the severity of the charges 2 counts of first-degree murder and brought up allegations of witness tampering against Melly. They argued the risk of flight was extremely high, especially with the death penalty on the table, pointing out that many countries wouldn't extradite him if he tried to flee to avoid capital punishment.
The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Demmons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here.
The defense team fired back at these concerns by emphasizing that the proposed security measures would make it virtually impossible for Melly to bounce. They also noted that his record label was ready to put up the paper for any monetary bond that might be imposed.
So, as to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. Give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be if there was a monetary bond in place. His record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label.
The defense team pushed back on these concerns, stressing that the proposed security measures would make it nearly impossible for Melly to flee. They also pointed out that his record label was prepared to cover any monetary bond set by the court.
Yeah, I had went to jail for the school shooting thing I did.
School shooting thing.
Yeah, I was shooting by the school.